B&S Utilities against Baskerville-Donovan, Inc.
I'd like to reserve 3 minutes, please. May it please the Court. My name is Tim Atkinson of Ortel Fernandez Colon Bryant of Tallahassee on behalf of Appellant B&S Utilities, Inc. This Court should reverse the final judgment and require Baskerville-Donovan, here I'll refer to as BDI, acting as a delegated city engineering department performing public functions on behalf of the City of Apalachicola to produce the public records sought and award a reasonable attorney's fees for BDI's unlawful refusal to abide by the public records law. This Court should not allow public bodies such as the City to delegate their public functions to entities like BDI without citizen taxpayer scrutiny.
So why was this a public function rather than just, contracting for services like wouldn't be covered?
This is a public function. I will say, first of all, below, the trial judge determined, and this is at record page 509, that under section 180.06, which authorizes the city to construct water distribution systems and associated facilities, the trial judge found, quote, thus, BDI has entered into a contract with the city whereby BDI is to perform public functions on behalf of the city as authorized by general law. However, after making that determination, that finding, the judge, not liking that outcome, devises out of thin air a new test, a turnkey, a policy level test, which requires a policy level making rule as to whether and what manner to provide such services.
Wasn't he trying to apply the Schwab case?
This is the delegation test, Your Honor. This is the first test, and this is the central issue in our appeal, we believe. This test that the lower court applied, this new policy level test, was actually previously discussed and considered by the Florida Supreme Court in the Schwab case, and that's at page 1032 of the Schwab case, where it discussed this policy level test that the trial judge adopts, but dismisses it. And certainly, clearly, there were no policy level issues at stake in the Fox versus Alligator towing case, 2nd DCA 1989, or the Stanfield versus Salvation Army case, 5th DCA 1997. That's a delegation test cited approvingly by the Florida Supreme Court in the Memorial 1 1999 case, or even the Putnam County Humane Society versus Woodward case, 5th DCA 1999. None of those cases involve policy level decision making. Instead, the delegation test is satisfied simply where the city delegates public functions. The trial court determined that that happened here. Certainly in section 27 of the agreement between B&S Utilities and the city, it states, quote, the engineer shall act as the owner's authorized representative during the construction period, shall decide questions which may arise as to the quality and acceptability of materials and furnished and work performed. This is all conceded by the appellee at page 3 of their answer brief. It's certainly in the record as well.
What about the Schwab case? Didn't the architect decide similar questions there?
The Schwab cases are similar, but what I was just talking about is the delegation test, which the Supreme Court has authorized. There's two tests, the delegation test and the Schwab totality of factors test. So further, in the record, Ella Moscona's P.E., the engineer for the Baskerville-Donovan, acting as the city of engineer, testified on behalf of Baskerville-Donovan. Question: if Baskerville-Donovan didn't do the construction management on this project, who would do it? Answer: I'm not sure. They would have to hire somebody to do it. Question: could the city do it themselves? Answer: I assume so if they had the staff to do it. This is concessions by BDI in the case below. Further, the city has retained BDI to act as the city engineer on all public works projects for over 15 years. BDI has acted repeatedly on behalf of and in place of the city, and I would refer to pages 4 through 6 of our initial brief, where there are literally dozens of examples where BDI is acting on behalf of the city.
All right, so your position is that BDI is subject to the public records law?
That is correct. They're subject to the records law, and they must produce the records in this case.
So, and they'd have to produce the records in any case, right, with respect to any project.
Any city project where they have adopted the public functions, which I submit.
Why just a city project?
Because in this case, they're working for the city as the city's agent, authorized representative.
That's not the way the statute is structured, right?
Well, it says whenever a private entity is acting on behalf of a public agency, and that's what BDI is doing in this case. It's also a constitutional right under Article 1 of the Constitution. This case is analogous.
If we find in your favor, does this case have to go back to the trial court? Because I assume that there's a lot of documents requested, and some are related to the work done on behalf of the city, and some are Baskerville-Donovan's records with regard to just what they,
well, certainly the public
their
records,
internal operating.
You're right, Your Honor. The public records request below did not seek the internal operating procedures of Baskerville-Donovan. It was only seeking the public records dealing with the public function that they were performing for the city of Apalachicola.
The statute doesn't say whenever acting on behalf of any public agency. It says that it defines an agency as any state, county, district, authority, or municipal, blah, 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 or business entity acting on behalf of any public agency.
That's what we have here, a business entity. That's what Baskerville-Donovan is. They're a private business entity where the city has delegated, as the trial court found, the public functions of the city of Apalachicola as authorized by general law. Now, the problem is the trial judge went a step further and created this new policy level test. That's not here. This case is analogous to the delegation of public functions in the Herald versus Orange County cases, 50 CA 1996 case. There, the county delegated to the private entity CKH the duty to determine whether vendors were complying with the county's minority business enterprise requirements. Thus, CKH was delegated the duty to determine third-party compliance on behalf of the county. Here, BDI was delegated the duty to determine compliance with the agreement between B&S Utilities and the city of Apalachicola for the provision of the 18006 duties and facilities. The trial court found BDI performed public functions on behalf of the city. As such, public access follows. Now, the second test, and I'll go through this, but the delegation test, which I was just talking about, when that's shown, and we believe it's shown here as the trial court found, there's no need to actually engage in the Schwab totality of factors test, but in the interest of abundance of caution, I think there's some factors that demonstrate that BDI is a public agency under the Schwab totality of factors case. This case under the Schwab test is analogous to the Dade Aviation Consultants case, 3rd DCA 2001 for several reasons. There's a whole litany of factors. I think there's just 5 factors I think that are critical. The first is funding and also the financial interest test. The Dade Aviation Court said, we see a significant public investment in the airport project. In this case, the undisputed testimony below was that between $23 and $35 million had been invested by the city in public works where the BDI was engaged by the city to perform public functions. The second factor is public property. In Dade Aviation, the DAC offices were on airport property at no cost to facilitate their work for the county.
But in the Dade case, wasn't DAC created for the sole purpose of entering into a contract with Dade?
Well, I believe the creation factor in DAC is a weak factor, and I'll tell you why. Because Dade Aviation Consultants just happened to be a group of engineering and construction firms who said, hey, let's get together and bid on this job. There are plenty of firms out there in the state of Florida that have all those disciplines under one roof, and they could have simply bid on it and won it as well. It just so happens that a group of people got together and said, let's bid on it. Certainly, the county did not form the Dade Aviation Consultants Group, and they still found it was a public agency. So under the public property test, though, BDI here enjoyed a rent-free office in City Hall at the city of Apalachicola to perform its public function duties. And also, it worked in the public domain where the water distribution system was being put in around the city. The third factor is the decision-making process factor. The record clearly showed in the Dade case that if Dade had not hired DAC, it would be performing the same airport management, construction management services that DAC rendered. Here, but for the city's agreement with BDI, the city would have to perform it and other engineering services that BDI provided. BDI has been the city engineer for over 15 years. Before that, it was Broward Davis. BDI was not merely the senior support staff as was in DAC. Here, BDI is the support staff. They're doing all these public functions as delegated by the city.
Wasn't DAC's sole source of income from the contract itself?
That joint venture sole source of income was that, but again, under the funding and financial test, the Data Aviation Court said, really, it's the significant public investment in the project is the factor. And in this case, again, you've got between $23 and $35 million the city has invested in projects that DAC has administered for them. And certainly in this case, the water distribution system has been administered using public funds on behalf of the city of Apalachicola. Now, the fourth factor, governmental functions, in Data Aviation, as well as in the Sarasota Herald Tribune case, 2nd DCA 1991, the issue was more of whether a government could provide the functions, not whether it's essential that the government actually do it. In DAC, the court noted that DAC performing services under that PSA agreement, DAC conceded that it acts on behalf of the county when it does that. Again, in this case, the trial court determined that BDI was performing functions on behalf of the city as authorized by general law. Further, there's an agreement, and the BDI has conceded that when it performs, it's an authorized representative of the city. And again, over and over, BDI has performed functions on behalf of the city. The last factor is the regulation factor. The 3rd DCA in Data Aviation and the 5th DCA in the News Journal Corp case, that's the 5th DCA 1997, both found that contract provisions were sufficient regulation to establish what they call real control over the private entity. The court below, in this case, found at record 512 that the city exercised a great degree of control over the results of services BDI rendered. So clearly, when you take the totality of factors together, as in DAC, Data Aviation, I call it DAC, clearly BDI in this case is an agency subject to 119. There's significant city and public involvement in Baskerville-Donovan in this case. Now,
did you want to save time for rebuttal?
I did. Looks like I'm finished. But just one thing. We would like also the court to reverse the final judgment as to attorney's fees. The Supreme Court in PHH Mental Health Services admonished and instructed private entities that when they're facing a public records request, they should undertake a Schwab analysis. In this case, BDI didn't do that. Instead, they went to an older case. The Parsons case is completely factually in opposite to this case. They did not act swiftly to determine their status. They did not get a declaratory judgment case as in PHH, as in Herald versus Orange County, or the Alligator Towing case. There was no uncertainty in the law at the time that this public records request went to BDI, as was the case in the PHH decision. So we ask that the final judgment as to fees also be reversed. Thank you.
Good morning. Tom
Counsel,
Gilday.
it's clear from the record in this case that in the absence of the contract with BDI, the city would have performed these services itself.
The indication, I think, of Ms. Mosconis is she doesn't really know whether the city could have performed the services or not. And the question is this. The city could perform the services if they hired licensed engineers who were experienced and professionals in doing design of engineering service for water systems, wastewater treatment facilities, that type of thing. The testimony in the case was from Ms. Mosconis of Baskerville-Donovan, and also Mr. Boyer, the only engineers that testified in the case, is that municipalities and governmental entities around the state, including Fort Lauderdale, many other large, small and large entities, hire professional engineers to perform the type of design and construction administration needed to design and construct a water system, wastewater treatment system, any of the other types of things, because they're complicated and difficult to engineer and construct. Now, I think I'd like to start just noting that when Judge Lewis considered this matter, he considered it initially, heard evidence on it, This was not a case that came up on summary judgment as the Memorial case did, in which we first heard about the delegation test, but rather it's the same case that was presented to the Supreme Court in 1992 in the Schwab case. Came to hearing, the court heard evidence as to the various factors. The court then made findings of fact as to those factors and then applied the totality of the factors to the particular examples. And I can go into those in some detail. This case came to Judge Lewis in the same manner. Heard evidence for day, heard testimony about each one of these factors. He went through, and it's detailed clearly in his opinion, that he found every single factor militated against finding that Baskerville-Donovan was performing a public function. Rather, what Baskerville...
Now, of course, they're arguing you don't even get to the factors. They're saying that for 15 years, this firm has supplied not only design services with respect to the water treatment and water distribution facilities, but every other, they've met every other engineering need of the city.
Well, I don't know they met every, but they certainly provided very significant engineering functions for the city in specific areas. Wastewater treatment, water facilities. The city was under a consent decree and had to modify its systems, which is indicated in the record, and so they hired Baskerville-Donovan in 1992 to begin the plan to come up with the design to modify the wastewater treatment system. In 1998, they got started on the water system. Their contract with Baskerville-Donovan is very specific in terms of what Baskerville-Donovan was to do for the city of Apalachicola. Now, if you talk about what the public function is, the public function is the city commissioners of Apalachicola decide that they are going to make improvements to their system, and they decide how they're going to raise funds and what they're going to do.
Well, on this question of raising funds, was there evidence that Baskerville-Donovan participated in exploring different financing options?
Yes, there was, and Baskerville-Donovan did in this case, like engineers do in many situations, where you have to get a permit from an entity or where you have to get a grant, and you have to do the type of analysis and the type of study that is submitted to the agency for the funding. And that was a specific contractual requirement of Baskerville-Donovan, was to assist the city in making application for these funds. Now, that is a design or contract type administration service. And so they were contracted to do that. The statute that Judge Lewis referred to, 180.66, and I thought it was interesting because what Judge Lewis did do is go through preliminarily where does this question of what is or is not a public function come from, and he went through 180.06, which generally authorizes municipalities and private entities to have a water system. And specifically, he noted at subsection 3 of it, he said subsection 6, that the entity has the ability to construct these improvements, is what the statute says, is that the entity may go forward and construct. Interestingly, it doesn't say that a public entity has the ability to go in and design these improvements. That's not in the statute. And certainly, Judge Lewis, when he focused on this particular section, says this section really provides no answer as to how we separate what is a public function and what is not a public function. And he turned to the Schwab test, which the Supreme Court in Schwab said, just because you contract with a governmental entity doesn't mean you're performing a public function for purposes of providing a business entity providing services on behalf of a public entity. And what the Supreme Court said in Schwab is that we need to go through an analysis and look at a number of factors. And that's what he proceeded to do. And he went through all of those factors. All those factors with the exception of the office in the building. Judge Lewis concluded those certainly demonstrated that Baskerville-Donovan was not involved in the business of the city, but was rather performing its design services. So the record comes to you at this point where we have factual findings.
Well, you're not saying that design services is all that was furnished?
No, I'm not saying. Certainly there's construction administration services, which, as the testimony in the record is, construction administration services are performed in virtually all projects where the engineer is hired to determine whether the contractor is completing the work consistent with what is shown on the design plans and specifications. And that's what Baskerville-Donovan did here, is reviewed the work that was done by B&S Utilities and made determinations whether it was consistent with the plans or specifications.
Or they made that determination as the city's representative?
And the contract, the specifications require that the engineer act on behalf of the city to protect the city, to make sure the city's getting what they're paying for. That's the contract here is no different than any other type of contract. That is the role that the engineer plays. Now, the contract also says that the engineer is an independent contractor and is not an agent of the city in terms of his status.
Council, the city provide Baskerville-Donovan office space on city property at no cost to Baskerville-Donovan.
I think there was an office, a small little office in a building, wasn't actually in the city hall, but was property that the city owned that was used for like a field service representative. Baskerville-Donovan has multiple offices throughout North Florida and other parts of the state. Not all of the work was done certainly in that office, but certainly it was available for their field guy who was there on site, doing the construction administration services.
It seems like Baskerville-Donovan, rather than being, a third-party kind of compliance agency where B&S did the work, they reported to the city, and the city said, Baskerville-Donovan, check, give us a report on whether they did the work. They served, rather than as a third-party compliance agent, they served as an intermediary. B&S could not really approach the city except through Baskerville-Donovan.
Well, the contractual documents, which is not unusual on a construction project, provides that the contractor, if they have a question about the plans or specifications, or they have a question as to whether or not there's compliance with the plans and specifications, they go to the engineer. They don't go to the owner. They don't go to the city. They go to the engineer, and the documents provide that the engineer is to interpret the plans and specifications. Now, this particular one said you're supposed to interpret those even-handedly, but that is your role and that is your job. That's what the city contracted with Baskerville-Donovan to do. And I think this is where we get caught up. If you take a look at, if you just assume every contract where you provide services for a city or a municipality, you could look at it in one sense as saying you're doing something on behalf of a public entity. I mean, if you just took it literally. I think the Supreme Court in Schwab recognized that that's not really what the test should be. Rather, the test needs to be, when you look at all of these factors, that you look at in terms of, are you funded by the entity? Is that your only source of funding, as in DAC? That was their only source, was the funding here. This is one of many clients that Baskerville-Donovan had. You look at does Baskerville-Donovan charge other clients for the same services? Yes. Did the city of Apalachicola control or direct how Baskerville-Donovan did its work? No, they did not. Where in the other cases that council's alluded to, the public delegation cases, we have the situation with the animal service. There you have the public statutes. You have statutes that direct, and you have certain criteria that control how you perform your service.
How is this different from the situation where a city, rather than having a city attorney, contracts with a law firm that may have many other clients to perform the city attorney functions? How is this different from that?
Well, I don't think that it is different if the attorney is contracted, if the attorney has a contract with the city that provides specifically what services you're going to provide. That's, I think, in the attorney situation, you tend to get pulled into it much more closely in terms of making decisions which do impact on how the public entity performs its governmental function in terms of advising, how you would interpret the law or how you would do those kinds of things. But in this case, the services by Baskerville-Donovan are not the types of services that the public entity would typically provide under any situation. Public entity doesn't design or
Well, just to follow Judge Roberts' question up, let's suppose that a firm has been retained to litigate on behalf of a public entity, and there's a work product privilege that eventually, though, expires, as I understand it.
It does.
And so could documents in the attorney's possession after that privilege had expired be kept? Could they refuse to disclose, or would they have to disclose under the public records law?
Well, you'd have to determine whether or not, first of all, they're public records, and are they a public record custodian? And certainly the statute does address, although it's not part of this appeal, if you're a custodian, what your duties, responsibilities are. So in that situation, if the attorney was performing services on behalf of the entity in the public function arena, I would say yes, they probably would be subject to the public, public records. Now, if you're in a situation where they've hired an attorney to do some other type of function, defend an automobile case or something like that, where you have an accident case, I don't think that doesn't blend itself over into the public function case, because there's really no interaction in terms of making public decisions.
Counsel, are you took to distinguish this privilege work product analogy based on the fact whether or not the counsel is providing a function which is considered a public function versus depending the city or county or the state in a regular slip and fall case?
Well, I'm just, in terms of trying to analogize an attorney situation, which is specifically provided by how it's handled in the statutes, with this particular case, which is not really addressed in the statutes in terms of how you deal with an architectural and engineering firm that provides design services. So I was simply trying to how you would look at it, applying the same principles that we have here. But here, this case is, there is no difference in this case and the Schwab case. They're identical, right down the road. In the Schwab case, the school board decided to construct some schools. They made a public function decision that we need more schools. We're going to have to get the funding to do them. It's the same situation we have here. I think I see that I'm out of time. Thank you.
Thank you, Mr. Gilday. Indistinguishable from Schwab.
I completely disagree with that. In this case, this kind of goes to Judge Lewis's question. What could they have done? I would just start with Data Aviation Consultants case right there. The third DCA found that the private entity was performing consulting services. These are the same kind of services at issue in this case. So certainly in Dade, we know that finding that the private entity could be doing it is true in other cases. The city of Tallahassee, there's undisputed record evidence in this case that the city of Tallahassee performs the same functions that BDI does. I'll cite you to record page 401. Also, Ella Mosconis testified below that if
But Counsel, the city of Tallahassee is much larger than the city of Apalachicola. It has greater source of funding than the city of
Sure, it still just says that, you don't have to hire an engineering firm to do it. It's your pleasure. You do it yourself, or you could delegate it out.
Yeah,
In
but
this case, the city has delegated it.
You agree that cities have the authority to do things in many cases that are not core governmental functions, that they take on things that are not necessarily seen as the government role.
Absolutely. In the Schwab case, the court found that there was no public function. In this case, the trial judge found, as a finding of fact, that the city has actually delegated public functions. In this case, that's at record page 509. So that is a significant difference than the Schwab case. And certainly, the delegation of functions here includes permitting, it includes getting loans, it includes all sorts of things. The bidding process, there's record evidence in this case that if you wanted to bid on a job, you're not going to the city to get the plans inspected, you're going to BDI's office to do that. Also, certainly law firms, my law firm, we do public entity work all the time for local governments. If we get a 119 it's not privileged, at the end of the case, we must turn these documents over. They're going to be public records. Lastly, I guess it's worth mentioning that our motion for fees in this case is unopposed. So we would ask that to be granted. This court should reverse the final judgment, finding that both the delegation test and the Schwab totalities of factors test have been met, and requiring appellee to immediately provide the requested public records for inspection and copying, and also award reasonable attorney's fees and costs for BDI's unlawful refusal to comply with the Public Records Act.
Thank you, Mr. Atkinson. We will